Hello friends, now in this presentation, the next point under the environment management is environment clearance. So from the name itself, it is clearly showing you what exactly it may contains. So the clearance for the environmental activities, the clearance for the industrial activities, for some of the modified activities, some of the operations, etc. So before starting the actual operation, before starting the actual project, that may be of different categories, we have to go for the environmental clearance. It means it is a green signal for starting, for modifying the different operations, different projects which are related to the environment. Because many of the operations, many of the projects are adversely impact on the environment, and that is why this criteria is there, that is environmental clearance from the Ministry of Environment and Forest, Climate Change under the central government. So what exactly this is, what is the procedure or administrative procedure of this environmental clearance is there, we will discuss it one by one. So this is administrative procedure for environmental clearance. Any person who desires to undertake any project or the expansion or modernization of any existing industry or project listed in the Schedule 1 shall submit an application to the Secretary, Ministry of Environment and Forest, New Delhi, or State Expert Appraisal Committee as per the type of project. So under this environment clearance, there are some guidelines or the procedural steps, and with reference to this Schedule 1, you can go in detail what exactly the new project is. Or if you are already having some project and there is some expansion activities or some modification or modernization in that project, then also you have to go for this Schedule 1 details, and then you can go for submitting the application to the Secretary, Ministry of Environment and Forest, New Delhi, or State Expert Appraisal Committee. Right? So this is the environmental clearance procedure, that is the application which you have to submit for to the MOEF New Delhi for the new project, for the expansion or modernization. Then the second point is the application shall be made in the pro forma specified in Schedule 2 and shall be accompanied by a project report which shall include an environment impact assessment report. So this Schedule 2 gives you the idea regarding the contents of this EI report, Environment Management Plan, prepared in accordance with the guidelines issued by the central government in Ministry of Environment and Forest. So under the central government and MOEF, this Schedule 2 gives you the idea or the contents in the EIA report, that is Environment Impact Assessment Report, or Environment Management Plan, that is EMP. So this is the Schedule 1 and Schedule 2 contents of this environmental clearance activity. Then if the project is related to the mining or pit head thermal power stations or hydropower or major irrigation projects, or the combination including the flood control, ports, harbors, then prospecting and exploration of the major minerals in areas above 500 hectares, then it is necessary to have the environmental clearance. Then you should go through the environment impact assessment report or EMP, which is the guidelines by the central government, MOEF and CC, that is called as Ministry of Environment and Forest and Climate Change. The central government in the MOEF and CC will convey a decision regarding the suitability or otherwise of the proposed site within a maximum period of 30 days. The said site clearance shall be granted for a sanction capacity and shall be valid for a period of 5 years of commencing the construction operation and mining. So it is necessary to go for the schedule 1 and schedule 2 activities, which is clearly mentioned in the previous slide, that if the project is related to the construction activities, related to the power station, related to the harbors, ports, etc., then you can go for this schedule 1 and 2 as per the guidelines of MOUF and CC. The report submitted with the application shall be evaluated and assessed by the Impact Assessment Agency, that is IAA, and if deemed necessary, it may consult a committee of experts having a composition as specified in Schedule 3. So, if the IAA is involved, so you have to go for the Schedule 3. So IAA would be the Union Ministry of Environment and Forest. The committee of experts mentioned above shall be constituted by the IAA or such other bodies which is recognized by the central government. The said committee of experts shall have full right of entry and inspection of the site, or as the case may be, factory premises at any time. So the IAA, that is Impact Assessment Agency, or the body which is constituted by the central government, can inspect your premises, can inspect your factory, which is under the environmental clearance procedure. I shall prepare a set of recommendations based on the technical assessment of documents and data furnished by the project authorities, supplemented by data collected during visits to sites of the factories, or if any undertaking is there, then you have to go for this undertaking also. Then there should be some interaction with the affected populations, environmental groups if necessary. So the persons which are the representative, who are the representative from this IA, can interact with the other people also, which are the residential people surrounding to your premises or your factory. Summary of the reports, the recommendations and the conditions subject to which environmental clearance is given shall be made available subject to the public interest to the concerned parties or environmental groups on request. So whatever the points discussed with the factory people, with the surrounding people, with the people who are going to discuss all these environmental impacts due to these activities or due to these projects, all these concerns should be reported to the government authority by this IA or some other bodies. Comments of this public may be solicited if so decided by I within 30 days of receipt of proposal in public hearing, after giving 30 days notice of such hearing in at least 2 newspapers. So public hearing is the part of this environmental clearance procedure, because um, what exactly the environmental impact, what is the adverse or negative impact of this project, or the modifications or the modernization or the expansion of that project, that can be decided by the public also. But the opinion should be an expert one and the point should be valid. If the points are valid and if there is a major adverse impact on the environment which is communicated by the public, then also the stay can be there due to this public hearing impact. So this public hearing advertisement or communication should be done with the help of 2 newspaper, at least 2 newspaper, and then within the 30 days of this proposal, public hearing should be done. Public shall be provided access subject to the public interest to the summary of the reports, EMP, at the headquarters of IA. The assessment shall be completed within a period of 90 days from receipt of the requisite documents and data from the project authorities, and completion of the public hearing where required and decision conveyed within the 30 days. So after completion of this public hearing, the decision should be taken. the clearance granted shall be valid for period of 5 years. So if the there is no objection by the public through the public hearing, if there is no issues, no adverse impact of these environmental impacts due to this project, then that project can be sanctioned for the 5 years period. No construction work, preliminary or otherwise, relating to the setting up of the project may not be undertaken till the environmental and or site clearance is obtained. So before clearance is granted by the central government, you can't do any type of construction work, you can't do any type of work on that site. Only after the clearance granted, you can go for the site development activities or the construction activities. So that is the power and authority of these IAA or the other bodies which are constituted by the central government. There are two types of project under these environmental clearance criteria, that is category A and category B. These categories depends on the size of the project and degree of potential impacts on the human health and natural and man-made sources. So what is the capacity of that project and what is the potential of that project, that is nothing but the adverse impact on the human health and natural and man-made sources. All categories A project required a prior environmental clearance from MOEF, that is Ministry of Environment and Forest. So what is that category A? Projects include all physical infrastructure whose size and cost is greater than certain minimum levels as defined in the schedule. So that is depending on the size of that project and cost of that project. Then environmental clearance for these projects are granted at the central level, that is at the central government level. Then physical infrastructure include projects in the ports, highways, water and sanitation, urban transport and solid waste management sectors. So these are the examples of these physical infrastructure and the category A projects which is going to monitor, scrutinize by the central government agencies only. All new national highways are classified as category A. So all the national highway, that is NH 1, 2, 3, etc. all are under category A. In addition, expansion of national highways greater than 30 km involving additional right of way greater than 20 meter involving land acquisition and passing through more than one state are categorized as a category A. So these category A activity, clearly all the national highways, that is new national highways, if the old national highways are not the part of this category A, but if the old national highways is going to expand more than 30 km, or if there is activities like land acquisition and if it is passing more than one state, then that national highway is called as category A project. What is category B? Category B covers projects with lesser size or capacity, because we have already discussed that category A is the more capacity, more size projects and having greater cost. Now the category B is having lesser size or capacity and with less cost. Environmental clearance for category B projects are granted at the state level. That is the main difference of this category A and B projects. So category A projects are sanctioned by the central government, by the central level, but the category B projects are going to grant or sanction at the state level. Each state has a dedicated department or boards as required by law, which would grant the clearance. The actual size definition depends on the sector or project type. For example, in case of ports, projects with handling capacity of more than 5 MTPA come under category A, while those with less than 5 MTPA are category B. So the project is, or the nature of project is same, but the capacity is different. So if the more capacity is there, then the category is A, and if less capacity, that is 5 MTPA for the same port, for the same project, then the category B is there. Projects can be new works, the expansion and modernization of existing projects, and changes in the product mix of existing products. So the project may be a new one, like national highway, maybe new one, or new port, or new project, etc. Or sometimes already the project is there, but we have to expand that particular project. That is nothing but the expansion activities. So that simple example is, if the capacity is going to increase from 5 MTPA to 10 MTPA, or the expansion of the national highway from 100 kilometers to 200 kilometers, like that, that is called as expansion activities. And some activities may include modernizations. So latest development, latest technologies, some modern changes may be the case in that project. That is called as modernization of the existing projects. So all railway projects with no exceptions are totally exempted. So this is the exemptions case, that is railway projects. So railway projects are exempted from the environmental clearance under the government regulations. Some external funding agencies such as JBIC may require an EI as a part of feasibility study or detailed project report. So this diagram or flow chart shows you the environmental clearance process as per the Environmental Impact Assessment Notification 2006. This is the process, that is submit application of MOEF, then get your of EI study, then communication or commencements or the baseline studies, draft of EI preparation, then apply to SPCB, that is State Pollution Control Board, for public hearing holding, then obtain public hearing proceedings, then applying for the Ministry of Environment and Forest, then scrutiny in MOEF, and then ESC meeting and presentation, and then they will decide whether to grant or reject this environment clearance or not. And all these activities required some duration, that is initially there are 60 days duration for the submission of applications and receiving the response, then 120 to 150 days duration for the TOR activities, 45 days duration for the public hearing activities, then CRZ recommendations for 15 days, then scrutiny in a MOE of 30 days, then ESC meetings, presentations 30 days, and granting for this environment clearance 45 days. So these are the different durations for these different control totally, but we can plan, we can generate the proper application for this environmental clearance. So you can refer the different form like 1A for the pre-feasibility report, then EI report and executive summary, then final environment impact assessment report form 1, site layout, public hearing, etc. So we must study all these types of contents for the environmental clearance process. So these are the different steps under this environmental clearance process for new projects. So there may be a modernization in the existing projects, there may be an expansion activity, etc. But this is for the new project. So the environmental clearance process for new project consists of 4 stages. Stage 1 is screening, stage 2 is scoping, stage 3 is public consultation, stage 4 is appraisal. So this screening, that is stage 1, is only for category B projects and the activities. So category B, we are knowing that less size and less cost projects and which can be sanctioned at state level only. So what exactly this screening stage is there? At the screening stage, which only applies to the category B projects, the state level expert appraisal committee reviews the application, that is form 1, to determine whether the project requires further environmental studies for preparation of an EI report or not. So this is the state level or state government activities. The applicant is going to submit the application in form 1 and state level expert appraisal committee is going to scrutinize this application and then they are going to decide whether to proceed for the next stage or not. Projects are then further categorized according to whether they require an EI or not. So the B, that is category B, is sub-classified as B1 and B2. So EI is applicable, that is B1, EI is not applicable, that is B2. Then second stage is scoping. At the scoping stage, detailed and comprehensive terms of reference, that is TOR, terms of reference, addressing all relevant environmental concerns for the preparation of an EI report are determined. This is carried out by the EAC, Expert Appraisal Committee, for category A projects and by the SEAC, that is State Level Expert Appraisal Committee, for category B1 projects. Scoping is not required for the B2 projects. So if the category A project is there, then the scoping is done by the EAC, and if the category B1 project is there, then the scoping is done by the SEAC, and category B2 projects are not eligible or applicable for the scoping activity. So the main concern is to prepare the TOR, that is terms of references, that is called as scoping stage. Then the next stage is public consultation stage. So we have already discussed that before sanctioning any type of clearance, we have to interact with the public. If the public are taking the objection related to this modernization or expansion or the new project, then you have to consider this objection from the public through the public hearing activities. So that may be the case of road, that may be the case of highways, that may be the case of some projects. All these categories must go through this public consultation, that is public hearing stage. Then the appraisal stage is there. This stage sees the overall and detailed scrutiny of the final EIA report, that is Environment Impact Assessment Report, which will have been presented by to EAC and SEAC. So all the detailed report, final environment impact assessment report, it means if the project is like that with that particular capacity, what exactly the activities of that projects are, or if there is a expansion or modernization in that existing activities, then what are the activities are involved, what are the parameters are involved, and due to these activities, process or parameters, what are the adverse impact on the environment is there. All these things are included in the presentation to the EAC and SEAC, that is Environmental Appraisal Committee and State Level Environmental Appraisal Committee. So after the presentation and detailed report, they are going to decide whether to sanction or the report or not, whether to grant the approval for this environmental clearance or not. If there is any recommendation, if there is a suggestion, if there is any corrective action needed, then this EAC or SEAC is going to give the communication to the respective industrial person. EC process for existing projects. In the case of expansion, modernization or changes to the product mix for existing projects, EAC and SEAC will decide on the recruitments for EIA and public consultations. So for the modernization and expansion activity, ESC or ACSC may decide for the recruitments for environment impact assessment and for the public consultation. Then applying for environmental clearance, and application seeking in EC must be made in form 1 provided in the notification. This must be made before commencing and construction activity or preparation of land at the site of applications. So we can't do any type of activity, construction activity, development activities, anything which is related to that project without the granting or permission as an environmental clearance. This environmental clearance process contains the application for the EC made to the concerned regulatory authority. Application must include the following, that is final EIA report, a copy of the videotape or CD of the public hearing proceedings. So everything is recorded. A copy of the final layout plan, a copy of the project feasibility report. For most of the projects, the EC remains valid for 5 years. The exceptions to these are river valley projects because this may consume more time than the 5 years, and that is why these are the exceptions, like river valley projects. So that may be the permission for the 10 years, and some for the mining projects that may be for the 30 years. But most of the plans are sanctioned for 5 years durations. So these are the environmental clearance procedures that is called as EC. Thank you.